Good afternoon, and thank you for joining us in these unparalleled times. As I'm sure you're all aware, the president nominated Coney Barrett over the weekend to fill the seat left open by the late Justice Ruth Bader Ginsburg. The president and Senate Republicans remain laser focused on confirming Judge Barrett at light speed. Reports are that the Senate will begin holding hearings this week or the week of October 12th and hope to take a confirmation vote by the end of the month of October. By committing to this course, they have virtually guaranteed that the Senate, which has already failed to pass additional legislation to provide aid to Americans badly in need of it as a result of the COVID pandemic, will be consumed by a rushed and chaotic nomination process. Instead of relief, President Trump and Senate Republicans offer only a nominee who, if confirmed, appears poised to strike down the Affordable Care Act and end its protections for people with pre-existing conditions. But the ACA is not the only thing that's at stake with this nomination. Conservatives have talked about using the courts to carry out a vision of returning our country to a pre-New Deal era, an early 20th century era. This is a vision that includes rolling back hard-fought rights Americans care deeply about: reproductive rights, environmental regulations, LGBTQ equality, civil rights, labor, the right of people to collectively organize to protect their rights, and consumer rights, and more are all at stake. Americans are already voting in an election that will determine who will be sworn in as president on January 20th, 2021. President Trump and the Senate Republicans are expressing contempt for the voters by attempting to railroad through this nominee. The nominee, should she be confirmed in this matter, will be forever tarred with the partisanship, hypocrisy, and bias that characterized this nominations process. So too would be the court she would join. Just a few housekeeping notes before we get started. First, ACS is a 501c3 nonprofit organization. It does not support political parties, positions, or candidates for public office. Second, please note that today's call is being recorded, and the recording will be available on our website, acslaw.org. Third, if you'd like to ask a question at any time during the call, please type into it the Q&A box on the bottom of your screen. We will be taking questions after our presenters are finished with their remarks, and we'll try to address as many as possible. If you're a member of the media, please include your outlet with your question, if you could. Finally, 1 hour of California CLE credit is available for this call. Please email us with, quote, Supreme Court stakes, unquote, in the subject line at info@acslaw.org to receive your certificate. If you're seeking CLE credit in a jurisdiction other than California, please consult the rules of that state's CLE board to see if it provides for reciprocity with California. CLE materials can be found on the event page of the ACS website and will be shared with all participants in a follow-up email. So we're extremely lucky to have, on very short notice, and we thank you for this, a team of experts joining us today. Professor Michelle Goodwin is the Chancellor's Professor of Law and founding director of the Center for Biotechnology and Global Health Policy at the University of California, Irvine College of Law, where she focuses on issues at the cross-section between constitutional law, health law, and reproductive justice. Professor Victoria Norris is the Ralph V. Whitworth Professor in Law at Georgetown Law, where she is one of the nation's leading scholars on statutory interpretation, Congress, and the separation of powers. Finally, we have with us Professor David Strauss, who is the Gerald Ratner Distinguished Service Professor of Law and the Faculty Director of the Jenner and Block Supreme Court and Appellate Clinic at the University of Chicago Law School, where he teaches constitutional law, federal jurisdiction, elements of law, and administrative law. The only bad thing I think about David is that unlike our other two guests, I don't know if he has a deep tie to the University of Wisconsin. Maybe he does, but the other two do. So you can defend yourself on that later. We have a lot of ground to cover, so without further ado, let's get started. Let me ask you to join in a conversation about the following. How do we explain the gap between textualism and originalism and reality to non-lawyers or the average American? Who'd like to kick that off? Michelle?
Well, what's interesting about these times is that we have a court that has a 5-4 majority that's all male, and many within that conservative majority cling to textualism and originalism, except some might critique that as being simply outcome determinative. We saw that in cases over the summer where those who would pitch themselves as being textualists come out in very different in terms of cases. But one thing that is fascinating is that as we see the sort of rise of religious discourse in Supreme Court cases, you have to contrast that against the founders who are very clear that there should be a very thick separation between church and state, which really leaves us to think that some of this is really quite dubious. And the truth of it is, foundationally, that there is no real way to have a functioning democracy and to think about equality in our nation were we to be strict conservatives on textualism and originalism, because then that would mean shutting women out entirely, and shutting out people of color entirely, and having a constitution that only protects the rights of landed, wealthy white men. And that's not the country that we live in. That's not where we are today. And I think our enterprise must be continuing the protection of civil liberties and civil rights as they have evolved with a better sense of humanity in our country. I'll start off with that and pitch it to my colleagues.
Great start. Victoria? Is she there? Maybe she's muted.
Oh, I have to unmute. We'll honor David and say he's not too far from Wisconsin.
That's true. It is in the right
old home. He's really not.
I happen to be a White Sox fan, so that can work.
Yeah. Anyway, I think Michelle hit it on the head. I mean, I study textualism, and I think it actually is the root of certain forms of originalism, which are public meaning originalism, which is to say you look at the text and that of the Constitution, and that's the springboard. But the reason I'm on this call today is I'm pushing back hard against this nominee's philosophy based on her work on statutory interpretation and textualism. She follows Justice Scalia to the letter. He himself was not consistent. He was a faint-hearted originalist, and I believe he was also a faint-hearted textualist. But I think people need to understand the method. So the way I describe this is, I say, well, pick any statute. Most people don't know that the court does more statutory cases than constitutional cases every year. And that means big statutes, like the Obamacare case. That went up 3 times. Okay, we'll just take that as an example. And here's the problem. The first case was constitutional. That was, Justice Scalia. If he's the goldstone here, then future Barrett would rule that it was unconstitutional. But moving beyond there, 2 other challenges. Why did 4 justices vote to hear these challenges? Well, one of these challenges, in my opinion, and there's one of Professor Strauss's colleagues, I think, agrees with me, who's conservative. It was basically a typo. It was one word, and this is what textualism does. Bill Eskridge and I call it gerrymandering the text. You pick and choose texts. So famously in statutory interpretation, liberals have been accused for picking and choosing legislative history. I never even use the word history. I use evidence, all right? If you have 2 meanings of words, you're always going to have to look at some other evidence, I think, to break that tie. But the problem here is the picking and the choosing. And I think we have to be very clear about that. And the Obamacare cases are very obvious examples. Even if you don't buy my interpretation of one word, switching part of the tax statute, which was the difficulty from by the state to for the state, even if you don't buy my argument, which I think is essentially Ryan Derfler's argument as well, that it was a Scrivener's error, this case would never have gone to the court when I went to law school. It never would have gone. Why? No one in Congress wanted that. They didn't want what Justice Scalia rewrote in the statute, which was exchanges for some states and cutting out national exchanges run by HHS. If you would ask any member, I'm sure, the senator would know, they would say, no, that's not what we were trying to do. But by virtue of this, sort of instinct for the capillary, I call it, it requires congressional perfection, which does not happen often in major bills. And it really causes a problem. I think it's part of a general trend toward, in structural matters, a very super strong presidency. The unitary executive is still there for several members of this court, and contempt for Congress. Look at the cartoon the chief used of Congress as acting as stooges in King versus Burwell, the second case I talked about. And look at the fact that he got the process wrong. The Senate parliamentarian called me up and said, Victoria, you know all about this stuff. You've got to write about this. He said the bill wasn't filibustered. That was wrong. So they don't even understand how Congress works. No doubt because of their confirmation hearings, they have contempt for it. But the Constitution that results from a very strong president and a weak Congress and a super strong court is one that is exactly what Donald Trump wants, because it will support him and it will pick and choose text of any statute. Pick your favorite statute to come out the way Donald Trump wants. That's why we need to push back on the method.
Not to mention a court that is becoming increasingly delegitimized because of the way in which its members are being chosen. You couple that with this kind of an executive and with a court that really was already in great trouble in terms of its legitimacy because of Bush v. Gore and Citizens United. You couple this together, and this is an incredible offense to Congress, which of course, kind of bothers me. So let's hear from David.
Thanks, Russ. And yeah, I guess the only defense I have to myself on the Wisconsin score is, come on, I just live a few miles away. No, don't I get some points for that?
Sure.
So let me say a word about originalism and then touch on something about some of the other very important themes that Russ touched on in his opening remarks and my co-panelists addressed. There are a couple of sort of myths associated. Well, I guess I'd start with this. The common sense objection to originalism that you might hear from an ordinary, non-lawyer who is told what it supposedly embraces is, come on, are you serious that we're going to try to resolve today's problems by digging deeply into what people thought in the late 18th century in a world that was completely different from ours in countless ways? Really? That's how we're going to solve these problems? In fact, one of the framers, I think it was Noah Webster, famous for the dictionary, but he was also in the founding generation, said, I'm going to paraphrase him, but this is the idea. He said, for future generations to try to follow what we are doing now would be the equivalent, I'll update it, would be the equivalent to someone coming along and saying, I've got the solution to all our constitutional problems. Let's see what they do in Australia, and let's do the same thing. And you'd say, why should we follow Australia? Why shouldn't we figure things out for ourselves? Well, we have a lot more in common with present-day Australians than we do with late 18th century white property owners clustered along the East Coast. So I think that sort of just common sense objection really tells you the story. But there are a couple of myths about it that tie in with what I think we have to worry about from what seems to be likely to be the next Supreme Court. One is that originalism actually disciplines judges. It doesn't really. If you look into the history, most of the time, maybe all the time, you're going to find what you want to find. There's enough in there. There's enough that's confusing. There's enough that's obsolete. There's enough that speaks to a different world, that if you go in there and you try to find something to support your views, you have a good chance of being able to find it. The second myth, which I think is important, is that originalism is small c conservative. It is not small c conservative any more than today's Republican Party is small c conservative. These people are radicals. And as Russ said at the beginning, what's going on with the court now is an example of that. The refusal to have hearings on Merrick Garland defied a tradition that when a president of one party puts up a moderate nominee of his party, a Senate, even controlled by the opposite party, will confirm that person. Republicans smash that tradition. They're about to smash another one by confirming a nominee By a narrow vote, they'll be lucky if they get 51 and the vice president doesn't have to break the tie. By a narrow vote, literally days before an election. These are traditions that have served the country and the court well. And the current Republican Party has smashed them to the detriment of the country and to the detriment of the court. Just one word about the possible turn that the next Supreme Court will take, and it's something Russ mentioned in his opening remarks. We focus a lot on Roe against Wade, as we should, and on affirmative action and on gun rights. I think the bigger threat is this, that the even bigger threat is that if there's a Biden administration and if the Democrats control Congress, there will be, of course, an ambitious legislative agenda because there are lots of problems that need to be addressed. And I can see a Republican Supreme Court throwing up roadblocks to that legislative agenda that will do immense damage to the people of the United States. And this will be a replay of the New Deal. And the New Deal ended up badly for the court. The delays the court inflicted on the country were bad for the country. Franklin Roosevelt managed to overcome those, but that was a different world. And I think that is the real threat. To some extent, it's been obscured from us because Republicans have controlled the presidency the last 4 years, have controlled the Senate longer than that. So there was really no opportunity for the Democrats to pursue an ambitious legislative agenda. The one time they did was the Affordable Care Act, of course, when they were able to do that. And we saw what happened with that, was that the opponents of the Affordable Care Act came up with a bunch of arguments that I actually think were borderline frivolous. The act barely escaped invalidation in the Supreme Court. Supreme Court will now, assuming its composition is changed only by the addition of Judge Barrett, will now be even more conservative. And I can see a scenario in which efforts by progressives actually to improve the status, the character, the quality of life in the country will be thwarted by people who claim to be acting in the name of 18th century gentlemen. And that is not a happy scenario for anyone.
That's an excellent progression. For me, talking about the possibility that whether it's originalism or textualism becomes a tool that essentially ends up, as you just said, David, being a way to frustrate the whole idea of our democracy, of representative government, that people can vote for people who will vote for change, and that it somehow can be subverted through these various tactics. So I appreciate that. And let me go now actually back to Roe v. Wade, though, because this is very much on people's mind. What do you say to people who claim that other conservatives have been put on the court, and yet Roe has not yet been struck down? How do you explain that to people?
So let's talk about this, which is that the trouble that we find ourselves in, the attacks on our constitutional democracy and the established norms exist clearly before Judge Amy Coney Barrett, was nominated and pre-exist if she is actually confirmed to the court. And I think that's really important for us to understand. The process problems that David has just mentioned are really important for us to understand, because that's a part of the attack on our democracy that in 2016, Merrick Garland couldn't even get a hearing. But as we turn to Roe v. Wade, let's be clear that Roe v. Wade itself was a 7-2 opinion authored by Justice Blackmun, who was a Nixon nominee, and that 5 of the 7 were Republican appointed justices. It was a different era and time. Between 2010 and 2013, it's important to note the rise of the Tea Party. And the Tea Party's agenda was not just voter suppression, anti-immigration, and various other xenophobic campaigns and anti-environmentalism. There was also a concerted effort to try to undermine reproductive health rights and justice in every way possible. So in that era, which is a direct flashback against Barack Obama, which can be seen now, I mean, at the time it was papered over and the racism behind it really wasn't given its due in media discourse. But now we can see it for really what it was. But what's important with regard to reproductive health rights and justice is that between 2010 and 2013, there were more anti-abortion, anti-contraception, anti-reproductive health laws that were proposed and enacted than altogether in the 30 years prior. a real concerted effort that was the kind of materialization of efforts that had been a decade in the making, and quite successful. What we know as trap laws, these targeted regulations of abortion providers. We see some of that litigated in June Medical and Whole Woman's Health. But I mention that because of your question, where some say, well, look, in the past, it was different. There were Republican nominees who came onto the court who upheld reproductive rights. Well, that happens to be true, but they were of a different ilk altogether, not of what it is that we see today. I mean, let's be clear that Title X, which protects the healthcare, reproductive healthcare for the most vulnerable of Americans, was shepherded through Congress by George H.W. Bush, signed into law by Nixon. This is just basic common sense. I mean, let's be clear that Prescott Bush, the father of George H.W. Bush, was the treasurer for Planned Parenthood. That was the Republican legacy. What we see today is not Republican in that traditional sense. It's actually something that's very different, that has been courted through evangelicals and those who are very orthodox in a very different view, who see as their primary goal, ending not only abortion rights, and that will come likely through 1,000 strikes, possibly, although there are cases that, if given the right trigger in some states, would end abortion rights altogether if they make their way to the courts. But let's be clear, we're also talking about sex education in schools. Things that 30 years ago, 40 years ago were not a question. Whether you got to learn about your body when you were in school, today is a question. And if you get it at all, in some states, it's abstinence only. The question of contraception, which many thought was resolved, not resolved. And when we look at the bare bottom health outcomes with this, they're dramatic. And so in a call like this, we tend to think just about the law, but I want to just give a flashpoint about what these outcomes actually mean, and then talk about pre-existing conditions. Well, what it means in real practical terms is that you have states that are coercing people into pregnancies at a backdrop where the US leads the developed world in maternal mortality, pressuring people into pregnancies when we know that a person is 14 times more likely to die by carrying a pregnancy to term than by aborting it. And you'd have to say, well, then, given those odds, what would we call that? When the state intervenes with your constitutional rights and says, we will coerce you and pressure you in a way that means you're 14 times more likely to die, what in the world do we call that? That seems cruel and unusual at the very best, right? And so I think it's really important to put these things in context, because so much now is the kind of rhetoric that we see coming out of party politics that's divorced from actual health and science. And abortion is as safe as a penicillin shot. And yet, if you were to follow the kind of rhetoric and narrative that we see coming out of members of Congress who are anti-abortion or coming out of the state, you'd think that it would be the most ridiculous thing for a woman to choose instead of something that actually is life-saving. But before I wrap up my comments on this, let's look at what else happens to be at stake with the court. So when we think about the Affordable Care Act, then pre-existing conditions matter, and they matter for women because women have traditionally paid more for the same kind of services that men have, and then shut out of them if they've had the condition before, such as a pregnancy or breast cancer or cervical cancer. These have real life meanings for people, or for the kids who've been able to stay on their parents' insurance until 26 years old. That also becomes vulnerable under a court that seeks to do away with the Affordable Care Act. So there's so much more for us to discuss, but I think it's really important to understand that where we are today pre-exists even Judge Amy Coney Barrett and the possibility of her coming onto the court.
Terrific answer, Victoria. Oops, we need to hear you, Victoria.
Too many Zooms today. Sorry for that. You know, I used to be a cynic about the abortion rulings, in the sense that I thought that this was a way in which the Republican Party could gain a lot of voters, right? And they were never really going to overrule Roe versus Wade. But, you know, I agree entirely with Michelle, and I love her fierceness about this, because just as I am fierce about textualism, etc., this is real life stuff, right? in areas that I care about, violence against women, you know, there's a court that just ruled that Congress has no power under the Commerce Clause to ban female genital mutilation. This is not a pro-woman court under anyone's imagination, all right? That same court is hearing they're hearing a case on hate crimes. So whether you like, there's a gay bashing case, all right? So that, we've got conservatives saying a case called United States versus Morrison, which involved the Violence Against Women Act. When they struck down a civil rights remedy there, they were using that to say Congress has no power to enact gay bashing or Jew bashing or Islam bashing laws, just to make it very clear that the real world is at stake here. And people like to wrap this up into very fancy stuff. And one of the things I love about my co-panelists is that they're extremely clear about the real life stakes for our democracy and for women's issues across the board, in my opinion.
Very good. David, can you finish that one for us?
Yeah, I mean, I agree with everything that Michelle and Victoria said. I just add a couple of notes. I think one thing progressives need to watch out for is we might see a burst of moderation from the court in the immediate aftermath of the election, and assuming the election goes in favor of Vice President Biden and assuming that Judge Barrett is put on the court. We might see that, for example, in the ACA case. The arguments in that case, I think, are even weaker than the arguments were in the other two cases, which is really saying something.
That's right.
And I wouldn't be surprised to see them reject that challenge in the ACA. It could also accept it, but I wouldn't be surprised to see them reject it. I would be careful that that does not cause progressives to put their guard down and think, well, maybe this court, maybe it's not so bad after all. After all, look what they did last term in the cases involving Trump subpoenas, in the case involving Dreamers. You know, they did all these things that look pretty moderate, and maybe they're not so bad. It was easier for this court to do those things in the Trump administration and look moderate. When they're faced with an administration that some of them will think in their own way is a real threat, because these are people, remember, some of them thought the Affordable Care Act was a dramatic threat to American liberty. If that's the way you're thinking, if you see an ambitious Democratic administration, you're not going to be so moderate. And I think an initial burst of moderation might disarm progressives who think, okay, it's conservative court. You know, we've had Republican majority courts for the last 50 years. Maybe we can live with this one for a while too. You know, Mitt Romney needs to be told that the court has had a majority of Republicans for the last 50 years. I don't know why he thinks it's a liberal court. I also don't know why he thinks the country is center right, since at last I noticed President Romney wasn't finishing up his term in office. But anyway, I digress. I think one thing we need to be, we progressives need to be careful about is, as I said, that this court, that we'll convince ourselves this court isn't so bad. I don't know what I think about expanding the size of the court. That's a conversation maybe for another time. But I can see the momentum being taken out of that effort when maybe it shouldn't be.
And Russ, could I add on to that, which is that this is where Victoria's work is so important. And thank you so much for that, David, because really what you're speaking to is the aftermath of Roe II, the kind of letting down the guard, that here have been these victories, Griswold, Eisenstadt v. Baird, capped off by Roe, and now breathe. Finally, women's humanity and personhood has been taken into account. Now we can get on with it with other things such as women in education, you know, filling the ranks in medical schools, law schools, and making their way through corporations and everything else. And who would have thought that the vulnerability of all of that fight was real, but it continues to be. And even if you look at the cases this summer that seem to be real victories, whether we're talking about Bostock or we're talking about June Medical, if you read in between the lines, then you see a number of things going on. If you read between the lines in Bostock, then you know that really while it's a groundbreaking decision that liberalizes rights for LGBTQ populations, you also see religion coming in as part of the discourse, and that being a wedge issue in the possibility of people being discriminated against, but using religion as a proxy to paper over for that. And you also see that in June Medical as well. What's interesting about that case is that we see Justice Roberts really defending the integrity of the court. In part, you can read his opinion as doing that. And if you read it even more closely, what you see is that he is grabbing hold to precedent, but he's making very clear that it's just this exception. Bring the court something else, and we'll look at it in a whole new light. He speaks very clearly to substantively disagreeing. He's still the conservative that he always was. He's still oppositional to abortion rights, but he cares about the reputation of the court. At least this summer, that was very, very clear. And it's also worth noting that what came about through Whole Woman's Health, which is that Justice Breyer and the others on the court, with Kennedy joining on in that case, said, look, we really need to do an empirical look. When states tell us that this is all about protecting women, we actually have to look in really scrutinizing ways at that to see if these laws really are about protecting women. That was the case where the Supreme Court struck down 2 Texas abortion provisions, right? And what you find in June Medical is that John Roberts says, basically, we don't have to do that, right? We don't necessarily need to do all of that scrutinizing, which basically means let's just take Texas at its word. Let's take Alabama at its word. Let's take Mississippi at its word. And anybody who can read pages of history about those very places would know you can't necessarily take those states at their word when it comes to racial equality or sex equality.
Well, David is really, both of you have really set this up for the last question I want to ask, whether it's a question of a burst of moderation or whether we overinterpret, as Michelle was talking about, some of the less than extreme conservative rulings of the last term. I guess I'd like each of the panelists to talk a little bit about an example or two of something that people might take for granted that might change with a 6-3 conservative majority on the court. We tend to, of course, think about the Affordable Care Act and reproductive rights, but what else should people be thinking about? Any one of you?
I think we should be thinking about elections. I'm not an election law expert, and I'd like to hear what David and Michelle have to say, or you, Senator. I'm very worried if they should take an election case this time. Of course, everyone thought Bush versus Gore was a very dangerous decision. But I'm also worried about elections moving forward. So one of the pieces of reform that I expect, if there is a shift from the current occupant of the office, is electoral reform, because one of the core problems here is partisan gerrymandering. The court has not been willing to address this. It has not been willing to say being for the Republican Party is not a compelling interest. And it's left it, and there's a case called Arizona Redistricting, I'm sure David knows this case, where the Chief Justice used a textualist reading of the Elections Clause and basically said Arizona could not have an independent redistricting commission, which is one of the solutions to this problem. And Rick Hazen, who's an election law expert, who's a colleague of Michelle's, and I are very worried, because this is exactly the kind of case that purports to be textualist, and a constitutional textualism that Amy Coney Barrett would just latch right onto. And that would be very, very dangerous, it seems to me, for any attempt to get at what is the core of what has happened to our government. Now, people disagree with that, but I think it's very important moving forward.
Well, that's just a very disturbing and very good example of what we're trying to alert people to. David, do you have one?
I agree about voting rights. I mean, I guess the thing that comes right to my mind is climate change, because there is no bigger problem confronting the humankind right now, I think, than that. And that is the sort of thing that can only be handled by ambitious legislative or administrative action. So it will require either a Congress committed to it or a very ambitious interpretation of existing laws. And either of those things is vulnerable. One of the difficulties we're facing now is that we are really in an era where it's easy to paralyze the legislative process. I hardly need to tell former Senator Feingold about that. And that means that a lot of things get funneled through administrative agencies. When the Obama administration wanted to attack climate change, they had to do this through the Clean Power Plan, because it couldn't get cap and trade through Congress. And that is extremely vulnerable to a conservative court that can just say, well, I mean, if you exceeded your authority under acts of Congress, we're not doing anything particularly radical here. We're just holding you to the laws of Congress. So I see that as given the magnitude of the problem, the difficulty of the problem, that and the possibility that the tendency of conservatives to see government overreach everywhere, even when, as in the case of the Affordable Care Act, the problems are crying out for a solution. If I had to say one thing that worries me the most on a very long list of worrisome things, I think I'd say that.
Yeah, I look forward to seeing one of the justices' opinion of what James Madison would have thought about climate change.
Right?
Not very much. Michelle?
There's such a laundry list, but let's start first with the power in the executive, which is that unlike what we've seen before, the concentration of power in the executive is quite strong, and that can be dangerous, whether we're talking about a Republican administration or a Democratic administration. And I think it's really important that we're clear about that, even though there are some that have said, well, look, if the Democrats had the opportunity that right now President Trump has and Senator Mitch McConnell, wouldn't they do the same? And it's worth thinking back to Jimmy Carter, who was faced with something very similar and was very reticent. He had a number of judicial vacancies to fill because the courts had expanded, and he was actually quite conservative about it, quite concerned about it, wanting to make sure that there was due deliberation, that this was a democratic process that would go forward. And so what we see now is something that is very different, that's disconcerting. And two other quick points. Education matters. It's worth noting that in the wake of President Trump suggesting that people should perhaps deal with COVID by drinking some bleach or injecting some things, that over the weekend, right after that, poison control centers were filled with calls of people who had actually tried that. What does this say about where we are in terms of a crisis of education in the United States? Something that we take for granted. And here I'm not just talking about race in the aftermath of Brown v. Board of Education. I'm talking about what a quality education actually means and what we're committed to in our nation as being vulnerable. And also, finally, just the very notion of what it means to be an equal citizen in the United States, I think is incredibly vulnerable. And we see that playing out in the streets across America. We see that with the rise of militia groups and people that have taken the Confederate flag out of Alabama and Mississippi all the way up to Michigan. And so these are concerns that I have, and there's a list longer, and I'm really happy to be on this call with my colleagues here who've helped to express other ones.
Well, this is a terrific panel, and we are lucky to have 175 people participating. So now let's give them a chance to ask you some questions by turning it over to our Jill Dash of ACF.
Thank you so much, Russ. Well, the first question actually goes to you, Russ, from Ken Doyle of Bloomberg Government, who wants to know about the stakes in Senate elections and whether it will help or hurt senators to vote for Judge Barrett to be confirmed, and whether any of them might seek to delay the vote until after the election, of course, keeping in mind always that we are a 501c3 and do not endorse anyone in a partisan way, but if you want to weigh in on what you think the stakes are.
Yeah, I do feel more constrained than in the past in answering this question, but I will say that, people over-interpreting what happens on this particular vote is a little bit of a danger. I think each state will have its own complexion with regard to Senate races, but we have seen where this issue of filling a Supreme Court seat has had an enormous impact, and many people believe that the 2016 election was significantly affected by the whole episode involving the death of Justice Scalia and replacing him. Many progressives I know, because I was a candidate at the time, we thought this would be beneficial if there wasn't a vote on this to Democrats, but it may have turned out the other way. So it's hard to predict. I do think it's very possible it will have a significant impact in a number of Senate races.
All right, for anybody who wants to take this next one, can we talk a little bit about affirmative action, and particularly something like the Harvard affirmative action case, which may end up back at the Supreme Court. What do we think happens to affirmative action with this potentially new court? Anybody that wants to jump in? I see Michelle flashing that smile. Go ahead.
It's just that here's some mystery, things that we don't know, right? So we're still under Sandra Day O'Connor and her Grutter window. We're still within that 25-year space. We don't know exactly how Justice Kavanaugh might rule in that regard, or necessarily Gorsuch. I mean, traditionally, it's thought that conservatives have no time for affirmative action, and that certainly will be the case amongst conservative members of the court. But I'm not exactly sure what the jurisprudence of a Kavanaugh is on this question. And I'm also not sure about Justice Gorsuch on this question, but I'd be curious to know whether David and Victoria have any insights on that.
Victoria.
I also share, I'm going to have to defer to David on this. I will say that, you know, the chief has taken very great pride in rulings on race that are contrary to what progressive views are. So, and I don't think he's going to give them up, Shelby County, for example, right? And so, and if he's a moderating force, to pick up on, you know, David's supposition, which I do believe he's tried to be a moderating force, although each one of those opinions has a poison pill in it, I think.
Exactly.
And usually on something arcane, like when can you rescind guidance or something like that. But I do think that if he's staked to that and he thinks that's part of his legacy, that it's not good news for those of us on the progressive side who believe that affirmative action is not necessarily affirmative, that it in fact is about equality. So that's my quick take on it. Over to David.
Well, thanks. And I agree. I'm actually quite pessimistic about this. I think what Victoria and Michelle suggested about the Chief Justice's views is right. He's really, you know, a lot of his opinions are kind of restrained, and even when it comes out in a certain way, you don't get a sense he is passionate about it. His opinions on affirmative action on race issues generally really have a different tone, and the hostility to affirmative action comes through. And it's really hard, to Michelle's point. I also don't know independently what Justice Gorsuch or Justice Kavanaugh would have to say, or for that matter, you know, Judge Barrett if she goes on the court. But it's really hard to see if the Chief Justice wants to do something aggressive and anti-affirmative action. It's really hard to see them dissenting from that and going the other way. I think actually where the sort of the real action is going to shift in affirmative action is to the lower courts, because there are already a couple of states, Michigan and California, that as a matter of state constitutional law, forbid affirmative action. And sort of what then happens is there are various lawsuits saying, you, University of California, Los Angeles, for example, or Berkeley, I'm not going to mention Irvine, because I'm sure they always play it straight. You're evading it. You are engaging in various kinds of subterfuge to sneak in affirmative action, even though it's been banned by the state constitution. And I think if we see a Supreme Court decision that says affirmative action is unconstitutional in all circumstances, which I don't know if that's more than 50%, but a real possibility, maybe more, I guess I'd say more than 50%, then the question will be, okay, various universities that do things because they really want, you know, the right kind of the sort of an entering class that's diverse in a variety of ways and that will enhance educational opportunities for all their students, and they do things, and then they're accused of violating the Constitution, how that plays out. And that's actually a respect in which the Republican domination of the lower courts is in a way even more troubling than the domination of the Supreme Court, because that's where the litigation will play out. That's where the findings of fact will take place and the questioning of motives. And you know, it should also, progressives should not take their eyes off the lower courts and the opportunities to make sure that the lower courts are, you know, following the law and not pursuing the same kinds of ideological agendas that we sometimes see from our conservative friends.
And to David's point, that has become part of the conservative playbook as well, which is repeat action at the state level, right? I mean, in some ways, that's the Jim Crow playbook, right? That's the antebellum playbook after the 13th Amendment. And you just see it being operationalized in modern times.
Uplifting. Let's go back to the Affordable Care Act. We have a question here about asking, is it possible to ask the court to defer its decision if it were to overturn the Affordable Care Act until the new Congress and president have time to pass a replacement, especially given President Trump's statement last night at the debate that he intended to offer a bill which would protect pre-existing conditions? Do we think that's possible? I guess, David, I'll put that to you.
Well, there is a legislative fix for the current supposed problem with the Affordable Care Act. It's not a bit of it is a constitutional problem, but it can easily be fixed legislatively. So if there is a progressive legislative majority in whatever form it would take, both houses of Congress and the president, then it could be fixed right away. It's sort of interesting to speculate what will happen if the court strikes down the Affordable Care Act, and whether Republicans in Congress, if they control Congress or if they can block action by Democrats, whether they will realize just how popular the Affordable Care Act is and how untenable a position it is politically to go back, in the ways Michelle outlined earlier, go back to the pre-Affordable Care Act days, especially now post-pandemic, when millions more people have what will count as a pre-existing conditions and insurance companies won't want to touch them. So I could see even if either there's no Democratic majority or if Republicans can block it, I could see action on that front. But I actually remain of the view that the court is unlikely to buy this particular attack on the Affordable Care Act. Partly for that reason, that the obvious popularity of the act, as well as because of the weakness of the legal arguments.
Anyone else want to weigh in on that before we move on to the next question? All right, going back to the topic of reproductive rights, Michelle, I'm going to put this to you. At oral argument in June Medical, Chief Justice Roberts asked both sides whether they believe the undue burden inquiry should be evaluated case by case. So do you think that's a route the court would take in narrowing reproductive rights?
Well, what Justice Roberts has made clear is that he's willing to entertain these targeted regulations of abortion providers that are different than what the court has previously struck down. And he's also made clear that he doesn't think that it's worth the court's time and that there's no judicial validity to looking at what he calls a balancing, right? To really understand whether these laws just present a kind of subterfuge when there's the claim that they're somehow benefiting women. So this idea of case by case, that very well is likely to be, right? Because that is the death by 1,000 strikes. Unless the court is able to get, so here's what abortion rights look like. It's either wholesale get rid of Roe, but that means a case making its way through a district court and getting over an injunction and making its way through a federal court of appeals on its way to the Supreme Court that says there are no exceptions, including for rape, incest, the life of the mother. The likelihood of that is very thin. So another enterprise with getting rid of Roe is to make it so difficult that essentially the right isn't there in the states that want to upend the right altogether.
And you talk about that as the sort of legal avenue, but from a messaging avenue, do you foresee that that's the preferred way to get at Roe, because it's just too difficult to swallow the pill that, the headline, the court struck down Roe v Wade today?
Well, I'm not exactly sure that the conservatives wouldn't mind that actually on this court. right? So it's just a matter of the right case coming before them. But clearly, we already have aligned justices on the court that would not mind that headline at all, that in fact might find some reverie in that headline. So I don't think that this is a court that minds that. I don't think that this is necessarily a Chief Justice that minds that, even though we saw his opinion in June Medical, because he also made clear that on substantive grounds, he did not agree with the liberals that he sided with. He did so at a time where we have to be clear that there have been attacks by the president in terms of the legitimacy of the court, and there's been such a groundswell by district court judges to say, you have to say something about this because these attacks have also been racialized. And so then you have Justice Roberts saying that, look, there are no such things as Trump judges, Obama judges, et cetera. So part of what we see, I think, in the cases this summer, including in reproductive rights, is upholding the legitimacy of the court. And let's be clear, to the extent, if the court had gone any other way, let's just imagine that in Brown v. Board of Education context, right? And you have the state of Louisiana saying, well, Brown only applied to Kansas. We're Louisiana. It doesn't apply to us. It would have been essentially the same in this case. So he saved the fight for another day.
All right, Victoria, a question for you. Is it hypocritical for the court to strike down, don't you love questions that start, is it hypocritical of the court, to strike down agency regulations on the grounds that they weren't passed by Congress, but then to strike down laws passed by Congress?
Well, there is a bigger picture here, and the question is getting at that. How is the court ruling? Is it ruling consistently with respect to the executive and the Congress? And I firmly believe they have unbalanced the separation of powers. They've always given themselves much too much authority in the separation of powers, but so they'll side with the executive, right? Now, as far as DACA DAPA, I think that's probably what this is referring to, so that they will strike down something like DACA DAPA because it should have been a law. Well, you know, that's, so I do believe that there's an inconsistency between the way that they're treating administrative regulations and the way they're treating Congress. It doesn't show up in every case, so you'll see exceptions. I mean, I think DACA DAPA is about immigration. I don't think it's about the rules of deference that would normally apply. So what happened in that case, where they refused to defer to a president, was simply about whether immigration was a hot button political issue, right? So you see Coney Barrett deferring actually to the public charge rule, right? Because, so she is doing the pro-presidential executive power stuff. Even though there's a textual argument, the hypocrisy I see is that there's a textual argument there for getting rid of the regulation, that it's not consistent with the statute, right? So I think the inconsistency will come out in the cases where it's highly politically salient, okay? We know from some of my colleagues over in the government department that there are lots of tax cases, lots of labor cases that, you know, might really have an impact on individuals, but their doctrine has some impact, right? But it's when it's highly politically salient, we know from behavioral economics and everything else that people are not going to be able to take their general meta views about the administration or the separation of powers and not infect those with their political priors, okay? So those are the cases where we want to have as much restraint as possible, and I don't think the methods they use, whether it's getting rid of Chevron or whatever they're saying, there are lots of inconsistencies, and I'm sure David, because he teaches administrative law, could give us even more. But I think mostly what you're seeing is that there are inconsistencies that will favor one party or another depending upon the politics of the underlying law, if that explains the hypocrisy.
David, do you want to comment on the appearance of hypocrisy and the court ruling politically one way or the other?
Well, I'll say this. I mean, we hear a lot about how there's the conservative attack on the administrative state. They don't like administrative agencies. They want to tighten up the non-delegation doctrine, which means Congress can't delegate chunks of power to agencies. Insist that agency heads can be removed by the president at will in all instances. these are kind of familiar lines now. Federal Society's conference is on this, as far as I can tell, every couple of weeks, on the need to beat back the encroachment of these faceless bureaucrats. And some of that language even creeps into the opinions of someone like the Chief Justice, who's otherwise, kind of restrained in his rhetoric. So they hate the administrative state, but when they think of the administrative state, they're thinking of EPA. They're not thinking of the Department of Homeland Security and ICE, which is, also the administrative state. And if you're thinking about, what really threatens people's liberty, what really threatens people's well-being, where are their members, sort of bureaucrats, government employees really running amok, getting out of hand, defying what the president wants to do, that's ICE. The reason that President Obama needed to issue DACA and DAPA, as opposed to just saying, stop deporting people who there's no reason to deport when we have such limited resources and so many undocumented people living in the country anyway. The reason he had to issue these as sort of locked in programs, official programs, as opposed to just giving directions, was that ICE agents in the field weren't listening to their instructions. They were deporting the people they wanted to deport. So that's the administrative state run amok. But that part of the administrative state run amok, the conservatives, a lot of them anyway, and I shouldn't paint with too broad a brush because there is a libertarian side of it, but the assault on the administrative state somehow loses sight of that. And to me, that's the real kind of hypocrisy, that we hate the administrative state when it's doing something to business interests, when it's doing something to the least well-off in society. Have at it, boys. That's what really gets to me.
Thank you, David. I've learned the hard way that an hour is an hour for the Zoom people, so we will be cut off in mid-sentence if I don't conclude this, and just say that this has been a marvelous panel. I want to thank everyone in the audience for joining this incredibly important conversation. I'm just so proud that ACS is able to put on this kind of program. ACS needs your support now more than ever as we fight to ensure that the Constitution is actually a force to improve people's lives, the lives of all people. So if you're not already a member of ACS, please consider joining us and supporting our work. And keep fighting for what you believe, because we need each and every one of you. Thank you and have a good evening.
Thank you so much.
Bye-bye.
Thank you.
Bye.